My name is Jim Hoover, and I'm a partner in the Burr and Forman Healthcare section. Today I'm going to talk to you about the Federal False Claims Act, qui tam lawsuits, and your role as a trustee of a hospital on how to protect the hospital and yourself from liability. The amount of false claims lawsuits that are being filed today is astonishing. In my opinion, it's not necessarily because the amount of fraud has risen. In fact, it's my opinion that healthcare fraud and abuse has actually decreased over the last several years. Quite frankly, I believe the cause of the rise in false claims litigation is because the plaintiff's lawyers have discovered the large amount of potential attorney's fees they can recover from such lawsuits. So the purpose of today's presentation is to help provide education to you as a hospital trustee on what is false claims litigation, ways to protect your hospital, and how to help protect you from personal liability as a hospital trustee. So let's start by reviewing the responsibilities and duties you have as a trustee or director. Directors typically have three general duties. Under Alabama, an officer or director of a corporation must discharge his duties as a director, 1, in good faith, 2, with the care an ordinarily prudent person in a like position would exercise under similar circumstances. This is oftentimes referred to as the duty of care. And 3rd, in a manner the director believes to be in the best interest of the corporation. That's often referred to as the duty of loyalty. Now, you as a director or a trustee or an officer of a hospital are entitled to rely on information provided by one of the following. You can rely on information from the office of the corporation, such as the CEO, the CFO, or COO. You may also rely on information from other employees, such as the compliance officer. You may also rely on advice from lawyers, accountants, or other persons about matters within the person's professional competence, such as healthcare consultants. You as a board of directors may also rely on a committee of the board of directors if you choose to form a subcommittee for a particular topic. One thing to keep in mind, a director or officer is not acting in good faith if he has knowledge concerning the matter that makes reliance on the above information unwarranted. Let's talk about the false claims generally. The federal false claims is codified at 31 U.S.C. 3729. While there are many subsections of the False Claims Act that deal with when is a claim false, when it's not, and all the defenses surrounding that. But for purposes of today, let's talk about the damages that can arise as a result of a violation of the False Claims Act. A person or an entity, in our case it's going to be a hospital, is liable for up to 3 times the damages, which what that means is if a claim, for example, is reimbursable at $1,000, the government has paid the hospital $1,000, then the government is entitled to 3 times that amount in damages, or $3,000. In addition, and the biggest part of the False Claims Act is the civil monetary penalties. And those can range from just about $11,000 to $22,000. And that's for each claim that the hospital files or submitted to the government. So for example, that $1,000 claim could cause damages up to $3,000, but then for civil monetary penalties, anywhere from an additional $11,000 to $22,000. So you can see how the numbers become so large so fast. Along those lines, I want to talk a little bit about some of the recent recoveries that the United States received in 2017. According to the government's website, recent healthcare fraud recoveries and penalties in fiscal year 2017 include things such as expected investigative recoveries of about $4.1 or so billion, and that's with a B. Additionally, the National Healthcare Fraud Takedown, which was a program established by the United States, as of July 2017, more than 400 defendants and 41 federal districts were charged with participating in fraud schemes involving about $1.3 billion in false billings to Medicare and Medicaid. And finally, approximately 826 civil actions were filed against individuals and entities, and that's just for 2017. So with those recoveries and the amount of damages as a backdrop, let's talk a little bit more about qui tam lawsuits, why they're filed, and how they're prosecuted. Most false claim lawsuits are filed by private individuals, and those private individuals are called relators. And in those cases, what happens is the individual acts if you will, as a private attorney general of the United States and files the lawsuit on behalf of the government. Well, why are relators filing the qui tam lawsuits? Is it because they want to right a wrong? I admit that I'm a bit jaded. I don't think that's the reason. I think it's because the large financial incentives that a successful relator will receive by either a settlement or a judgment. For example, relators are entitled to a contingency fee of any settlement or judgment. These fees typically range between 15 and 25% of the recovery, but can be as much as 30% of any amount recovered by the United States. So with the penalties ranging between $11,000 and $22,000 plus 3 times the amount of the claim, the amounts that are subject to any type of qui tam lawsuit or false claims case are staggering, and it provides an incentive for the relator to file such suits even if there's not much merit to the lawsuit. As a result, even a defendant hospital with good defenses has a risk of paying a large settlement or large judgment. This in turn generates high settlement values because most defendants, quite frankly, don't want to risk enormous judgments. Many plaintiffs' lawyers find the possible payday without much risk very attractive, which has caused the number of qui tam complaints filed to increase year over year, even if the cases are quite speculative. So we've talked about the potential large damages and recoveries that are arising because of the qui tam cases and false claims lawsuits. Let's talk a little bit about how you as a hospital trustee will learn that your hospital is a possible defendant or is under investigation. First, a false claims case is usually filed under seal in the U.S. district where the hospital is located. As a result, that gives the U.S. Attorney's Office time to investigate the substance and the basis for the lawsuit. It does this by issuing what is called a civil investigative demand, or a CID for short. Well, what is a CID? It is essentially a subpoena issued and served upon the hospital. It requires the hospital to produce documents, answers interrogatories, and possibly even put up employees such as the CEO, CFO, or nurses for depositions. Although the existence of a qui tam case is initially filed under seal and is intended to be confidential, a careful analysis of the CID can often offer clues of what the United States is investigating. The types of documents requested in the subject matter oftentimes reveals the conduct that is the subject of the lawsuit. For example, it may ask for claims information or medical records pertaining to cardiology patients, lab patients, or various other lines offered by the hospital. So a careful analysis of the CID oftentimes will offer clues of what is being investigated and what is being alleged in the qui tam complaint. Once you have gotten a CID, hopefully the CEO will bring it to the board's attention. How does the hospital and how do you as a trustee want the hospital to respond to a CID? Well, first and most importantly, contact outside legal counsel immediately to handle the response. This is because the lawyer can protect most of the investigation, which will include notes, work product, other documents, emails with the attorney-client privilege, attorney work product, and a doctrine that is also known as made in anticipation of litigation. Counsel for the hospital will also be the party that contacts the United States Attorney's Office. And this is important because oftentimes the CID is not clear specifically on what type of documents it's requesting, or the scope of the request is extremely broad. So the hospital's lawyer will want to know exactly what the CID is asking for. Hospital's lawyer will also want to limit the scope of any response and typically get an extension of time to respond to the CID. Every bit as important as hiring outside counsel, the hospital should carefully assemble a response team for both the substantive response as well as the procedural response. And what I mean by this is the substantive response is, in my example above, if the CID is asking for cardiology patients and cardiology claims, is those individuals that have specific information or subject matter expertise about cardiology claims. What I mean by the procedural response is oftentimes it's going to ask for a large amount of electronically stored information, such as emails, patient records, claims data, And so the procedural aspect of what is the best way to gather and collect all of the ESI that is stored in the hospital. And keep in mind that this is going to include inevitably emails. They're almost always responsive to the CID. So it is important that the emails that are potentially responsive are collected, saved, searched, and responsive emails produced. And this can be and is a huge undertaking and one of the biggest areas of risk for the hospital. As a result, oftentimes I recommend to the hospital that it consider hiring an outside electronically stored information vendor to collect, store, and run the search terms on the hospital's data. I also recommend this as the ESI vendor is in a better position to understand all the nuances of electronically stored data and all the many locations it can be located at the hospital. Also critical in responding to a CID is immediately issuing what is called a litigation hold notice to employees. Quite simply, what a litigation hold notice does is it tells the employees not to destroy, remove, edit, or change any information that may be responsive to the CID. And this is important to prevent spoliation claims by the United States or Relators Council. So once you've initially identified the CID, you've issued your litigation hold notices, and you've retained outside counsel, the next thing that you'll have to do is actually conduct the internal investigation. That typically will last anywhere from several months to up to a year or sometimes even longer. Once the internal investigation is done, we as the hospital have turned over all the documentation to the United States. Eventually the United States will have to make a decision as to what it wants to do with the case. Typically what the government wants to do is extend a settlement offer to the hospital to see if the hospital is interested in settling the cases. Quite frankly, sometimes that's fruitful and productive, other times it's not. So if settlement attempts are unsuccessful, the complaint will come out from under seal, be served on the defendant, which in our case would be the hospital, and the civil court process will begin much like any other lawsuit. If, however, the government sees the merit in the allegations, not only will the case come out from under seal and be served on the defendant, but the government will intervene in the case and take charge of the case. If, however, the government doesn't see any merit in the case or doesn't have the resources, quite frankly, to pursue the case, the government may decline to intervene and allow the relator to prosecute the case on its own. You as a trustee, how do you protect yourself and how do you protect the hospital? Well, the first place to start is looking at the board members and did you as a board member comply with your duty to the hospital? And again, just for refresher purposes, the duty of care does not require the board to install and operate a corporate system of espionage to ferret out wrongdoing, which the board has no reason to suspect. Again, as a trustee, you must exercise your duty in good faith, exercise the duty of care, and the duty of loyalty. And in fact, you as a trustee enjoy a presumption of good faith in the absence of reckless indifference or deliberate disregard of information. You as a trustee can also rely on information and opinions and answers that you've received from other individuals such as the officers and employees, legal counsel, accountants, or other professional expertise. And again, hopefully you'll have a board committee for compliance matters that will have investigated things and issues and made a recommendation to the full board, which you as a board member can rely on. One other thing to keep in mind, you generally have no liability where you act in good faith and with the belief that the decision is in the hospital's best interest. So with that as a backdrop, let's look at what concrete steps you can take as a trustee to help protect yourself and the hospital. First and foremost, look at the board involvement in compliance. You as a board member should make sure the hospital has a compliance program that is active and alive. Well, what do I mean by that? First would be reports. The board should routinely receive reports from the hospital's compliance officer, whether this is at every board meeting or on a routine basis. The board should require that the hospital's compliance officer make routine reports of any suspected conduct, audits, anything that the compliance officer feels is important to present to the full board. Next, you may decide to establish a board compliance committee. This committee, again, would handle more of the day-to-day, ongoing, routine monitoring of the compliance activities of the hospital. The committee can then make routine reports to the full board and also handle any initial compliance concerns or problems. Next, very much important to any type of compliance program, is education. The hospital should ensure that the compliance program emphasizes educating its personnel on areas of risk and compliance with the laws. For example, are there any types of particular issues with claims that are being filed, new types of claims, and it's important to educate the employees to be on the lookout for any conduct that may be a potential violation. Additionally, you should have a robust auditing program. And when I talk about auditing, I'm not talking about just auditing claims. Also audit the documentation, the medical records. Make sure that the medical record supports the claim that is billed. Does it support medical necessity? But every bit as important as auditing claims is also performing a legal audit, such as reviewing contracts with potential referral sources to make sure that the contracts are in order and that they are being followed according to the terms of the contract. An important area that is often looked at by the government or medical directors. Are they being paid appropriately for the time that they're providing to the hospital? Next is training. Trustees should ensure that the hospital trains its personnel in compliance issues and how to report concerns. Next, reporting mechanisms for employees should be in place so that the employees know how to report any compliance concerns. Trustees should also make sure the hospital publicizes to its employees and visitors how to report suspected behavior or potential violations. The hospital should then document the steps it took to investigate the reports and conclusions made. And finally, and perhaps most importantly, is corrective action. If the hospital understands or finds out that an individual or employee has violated any of its compliance policies and procedures, the hospital should take corrective action to reprimand that employee. Corrective action can range anywhere from a verbal reprimand all the way up to termination. Anything that would be appropriate to the conduct for which the employee violated. Additionally, corrective action shows that the hospital is serious about compliance and intends to comply with the law. This presentation hopefully did not scare you away from being a trustee. That was not my intent at all. Rather, it was help educate you on what you can do to protect yourself and your organization from false claims or qui tam lawsuits. I know your hospital appreciates the service that you do for your hospital. So hopefully I've provided you some useful information and want to thank you for your time and your service to your hospital.